Flamur Schala Fokusstrategie Grendelstraße oder Grendel 19 6004 Luzern. Ich lese da ein weiteres, das mal lese ich ein Sentencing Judgment vor. Ich lese zuerst mal den Text ein und dann, sobald ich alle Texte habe, werde ich sie einzeln anhören und in erster Linie Kommentare, Meinungen, Sonstiges oder Zusammenfassungen davon auf meinen privaten Seiten, auf der Facebook-Seite flamur.schale.90, aber auch auf meinem LinkedIn-Profil, und zwar private Profil, veröffentlichen. Je nachdem schaue ich dann auch, dass ich vielleicht auch auf YouTube als Kommentar, aber dann schreibe ich das hier Kommentar von mir persönlich, dass ich dann und als Kommentar eine Zusammenfassung noch liefere. Aber dann werde ich das markieren, dass es ein privater Kommentar wäre. Aber schon von meinem Account Fokusstrategie. Also ich würde den verwenden und dann auch noch als Flamur Schale das sozusagen unterzeichnen im Sinne von, dass ich sage, das ist ein privater Kommentar. Also. Und befrage einfach auch einen öffentlichen Kommentar schreiben, dann kann ich darauf eingehen. Material von mir findet man auf focus-strategie.ch oder auch auf mathematica.ch. Also, ich lese jetzt ein Sentencing Judgment ein, oder liefere sozusagen die Audioform davon. International Tribunal for the Prosecution of Persons responsible for serious violations of international humanitarian law committed in the territory of the former Yugoslavia since 1991. Case number IT 9622T, date 29th of November 1996, original in French and English. In the trial chamber before Judge Claude Jorda presiding, Judge Elizabeth Odayo Benito, Judge Fuad Riyad, Registrar Mrs. Dorothy de Sampaio Garrido Neik, Registrar. Judgment of 29th of November 1996. The prosecutor versus Drazen Erdemovic. Sentencing judgment. The office of the prosecutor, Mr. Erik Ostberg, Mr. Mark Harmon. Counsel for the defense, Mr. Jovan Babic. It starts with 1. The proceedings. A. Background. One. On 28 March 1996, Judge Fuad Riyad, pursuant to the provisions of Rule 90 bis of the Rules of Procedure and Evidence in brackets hereinafter the rules, ordered the transfer and provisional detention in the detention unit of the International Tribunal for the former Yugoslavia, hereinafter the International Tribunal, close brackets, of Drazen Erdemovic, then being held by the authorities of the Federal Republic of Yugoslavia, in brackets Serbia and Montenegro, close brackets, in connection with a criminal investigation into the war crimes committed against the civilian population in July 1995 in Srebrenica and its surroundings. Judge Riyad thus granted an application from the prosecutor of the International Tribunal, who considered that Drazen Erdemovic could provide additional evidence in the case against Radovan Karadzic and Ratko Mladic. 2. On 29 May 1996, the prosecutor of the International Tribunal, pursuant to Article 18 of the statute, submitted to the reviewing judge an indictment against Drazen Erdemovic, The latter is accused of having committed a crime against humanity, in brackets, Article 5 of the Statute, close brackets, or a violation of the laws and customs of war, open brackets, Article 3 of the Statute, close brackets, for the following. Drazen Erdemovic, born on 25 November 1971 in the municipality of Tuzla in Bosnia and Herzegovina, was a member of the 10th Sabotage Detachment of the Bosnian Serb Army. On 16 July 1995, he was sent with other members of his unit to the Branjevo collective farm near Pilica, northwest of Zvornik. Once there, they were informed that later that a Muslim man from 17 to 60 years of age would be brought to the farm in buses. The men were unarmed civilians who had surrendered to the members of the Bosnian Serb Army or police after the fall of the United Nations safe area at Srebrenica. Members of the military police took the civilians off the buses in groups of 10 and escorted them to a field next to the farm buildings, where they were lined up with their backs to a firing squad. The men were then killed by Drazen Erdemovic and other members of his unit with the help of soldiers from another brigade. On 29 May 1996, Trial Chamber 2 requested the government of the Federal Republic of Yugoslavia, in brackets Serbia and Montenegro, close brackets, to order its national courts to defer all investigations and criminal proceedings against Drazen Erdemovic to the International Tribunal. 3. On the same date, pursuant to Article 19 of the Statute and Rule 47 of the Rules, Judge Rustam S. Sidva confirmed the indictment. On 30 May 1996, Drazen Erdemovic appeared for the first time before the trial chamber. At the hearing, he pleaded guilty to count number 1, crime against humanity, of the indictment. Having verified that the accused had entered his plea fully cognizant of what he was doing and having heard his additional statements, the trial chamber decided to accept as final Drazen Erdemovic's guilty plea. Accordingly, with the consent of the parties, the trial chamber also decided that, for the remainder of the proceedings, it would dismiss the second count, violation of the laws of customs of war, which had been charged as an alternative to the first. Further, the trial chamber ordered the psychological and psychiatric examination of the accused. It entrusted this task to a commission of 3 experts, 2 designated by the International Tribunal and a third selected from a list presented by the defense. Last, pursuant to Sub-Rule 62 in brackets V or 5, no V, close brackets, of the rules, the pre-sentencing hearing was scheduled for 8 and 9 July 1996. 4. On 24 June 1996, a status conference was held in preparation of the pre-sentencing hearing, during which the trial chamber decided that protective measures would be taken for a witness called by the defense. 5. On 27 June 1996, the Commission of Experts concluded in its report that Drazen Erdemovic's mental condition did not permit his appearance before the trial chamber at that time. The report's conclusion indicated that the expert medical commission is of the opinion that, in his current condition, the accused, Drazen Erdemovic, because of the severity of the post-traumatic stress disorder, can be regarded as insufficiently able to stand trial at this moment. It also suggested that Drazen Erdemovic be evaluated a second time within 6 to 9 months. 6. At a status conference held on 4th July 1996, the trial chamber heard that parties regarding the above-mentioned expert report and the action to be taken in respect of the proceedings. First, since Drazen Erdemovic agreed that cooperation with the International Tribunal was in his interest, the trial chamber decided to grant him leave to testify during the proceedings pursuant to Rule 61 in the case The Prosecutor versus Radovan Karadzic and Ratko Mladic, case number, in brackets, I think it's the case number IT 9518 R61, close brackets. The trial chamber decided to postpone the pre-sentencing hearing and also ordered that the same commission of experts make an additional psychological and psychiatric evaluation and submit a report by 1 October 1996. Ich habe jetzt damit angefangen, das einzulesen. Ich werde das jetzt auch einlesen. Ich denke, in dieser Liste, wo über 20 Jahre, also Liste, die ich jetzt hier habe, solche Texte, werde ich wahrscheinlich nachher nur noch die Press Release einlesen. Ich denke, sonst tut das über geht das über das Ziel hinaus oder das, also ich habe jetzt damit angefangen und ich mache jetzt das noch. Und das ist ein Text von 25 Seiten und sonst zum Teil sind es solche Texte bis 200, 300, 500 Seiten lang. Ich mache es jetzt einfach mal, aber nachher, also auf dieser Playlist kann man dann vor allem Press Release oder ähnliches hören. Also 7. On 5th of July 1996, Drazen Erdemovic testified during the hearings held pursuant to Rule 61 in the aforementioned case. 8. In its report submitted on 17th of October 1996, the Commission of Experts declared Drazen Erdemovic competent to stand trial and reached the following conclusion. The Commission of Medical Experts shared the opinion that under his current condition, the accused Drazen Erdemovic is sufficiently able to stand trial. It added that no additional measures need to be taken for the appearance of the accused. 9. A further status conference was held on 18th of October 1996, at which the parties agreed to submit briefs to the trial chamber by 11 November 1996. By the 11th of November 1996. About the general practice regarding prison sentences and mitigating and aggravating circumstances. The trial chamber also set the date for the pre-sentencing hearing, which took place on the 19th of and 20 November 1996. On 18 October and 5 November 1996, the trial chamber issued 2 orders for the protection of defense witnesses designated by the pseudonyms X and Y. B. The guilty plea. So. As stated above, Drazen Erdemovic pleaded guilty pursuant to the provisions of Article 20 in brackets 3, close brackets, of the Statute and Rule 62 of the Rules to the count of a crime against humanity and stated his consent to the version of the events as set forth briefly by the prosecutor. He added the following, however: Your Honor, I had to do this. If I had refused, I would have been killed together with the victims. When I refused, they told me, if you're sorry for them, stand up, line up with them, and we will kill you too. I am not sorry for myself, but for my family, my wife and son, who then had 9 months, and I could not refuse because then they would have killed me. The trial chamber, which had also ordered the psychological examination of the accused, considers that at this point in the proceedings and before reviewing the merits of the case, it should examine the validity of the guilty plea. That validity must be assessed in formal as well as substantive terms. So, and then it's unterteilt. There's a subcategory 1, formal validity. The trial chamber wished to ensure that, starting from the initial appearance, the plea was made voluntarily and in full cognizance of the nature of the charge and its consequences. In addition, it asked designated experts whether the examination of the subject, in brackets revealed, close brackets, that he currently suffers from a psychiatric or neuropsychiatric disorder or from an emotional disturbance which affects his judgment or his volition. volition, ville, la volonté. Volonté. 12. Although in their first report, this was cited by the defense, the experts found that Drazen Erdemovic was suffering from post-traumatic stress disorder. PTSD. Their second report stated that his conscience, in brackets, was, close brackets, clear. His conscience was clear, or his conscience clear, and that he showed no signs of memory impairment. Further, the consistency of Drazen Erdemovic's assertions in respect of his guilt firmly reiterated on 4th of July 1996, and that the pre-sentencing hearing of 19 and 20 November 1996. For example, after the last medical and psychological examination provides more than adequate confirmation of this. The judges are therefore convinced that Drazen Erdemovic was able to understand the significance of his declarations when he pleaded guilty on 30 May 1996. 2. Substantive validity. The trial chamber would first point out that the choice of pleading guilty relates not only to the fact that the accused was conscious of having committed a crime and admitted it, but also to his right, formally acknowledged in the procedures of the International Tribunal and as established in common law legal systems, to adopt his own defense strategy. The plea is one of the elements which constitute such a defense strategy. Furthermore, the accused's cooperation in the Rule 61 hearing against Radovan Karadzic and Ratko Mladic and his reliance upon other mitigating circumstances, in brackets Rule 101 of the rules, close brackets, clearly fit into that strategy. While the defense has full discretion over their strategy it decides to adopt in response to the prosecution, the trial chamber must nonetheless ensure that the rights of the accused are actually respected, and more specifically, the accused's right to counsel. In the casing point, this was done in accordance with the provision of Rule 62 of the rules. 14. Nevertheless, the very contents of a declaration which is ambiguous or equivocal might affect the plea's validity. In order to explain his conduct, the accused argued both on obligation to obey the orders of his military superior and physical and moral duress stemming from his fear for his own life and that of his wife and child, in and of themselves. These factors may mitigate the penalty, depending on the probative value and force which may be given to them. They may also be regarded as a defense for the criminal conduct, which might go so far as to eliminate the mens rea of the offense, and therefore the offense itself. In consequence, the plea would be invalidated. The trial chamber considers that it must examine the possible defense for the elements invoked. 15. The defense of obedience to superior orders has been addressed expressly in Article 7, in brackets 4, close brackets, of the statute. This defense does not relieve the accused of criminal responsibility. The Secretary General's report, which proposed the statute of the International Tribunal and which was approved by Security Council Resolution 827 of 25th of May 1993, in brackets S/RES/827, in brackets 1993, closed brackets, close brackets, clearly stated in respect of this provision that, at most, obedience to superior orders may justify a reduced penalty should the International Tribunal determine that justice so requires, in brackets S/25704, paragraph 57, close brackets. 16. In respect of the physical and moral duress accompanied by the order from a military superior, in brackets sometimes referred to as extreme necessity, close brackets, which has been argued in this case, the statute provides no guidance. At most, the Secretary General refers to duress in paragraph 57 of his report and seems, moreover, to regard it as a mitigating circumstance. 17. A review by the United Nations War Crimes Commission of the post-World War II international military case law, as reproduced in the 1996 report of the International Law Commission, in brackets, supplement number 10, in brackets A/51/10, close brackets, page 93, close brackets, shows that the post-World War II military tribunals of 9 nations considered the issue of duress as constituting a complete defense. After an analysis of some 2,000 decisions by these military tribunals, the United Nations Commission cited 3 features which were always present and which it laid down as essential conditions for duress to be accepted as a defense for a violation of international humanitarian law. 1. The act charged was done to avoid an immediate danger, both serious and irreparable. 2. There was no adequate means of escape. 3. The remedy was not proportionate to the evil. In brackets, rapport de la Commission du droit international 1996, page 96. These criteria have already been identified in the Krupp case. The trial chamber notes that these military tribunals have on occasion characterized the said criteria in different ways. The variations in the criteria have defined them more precisely. In addition, some of the decisions set forth other criteria and therefore further narrow the scope of that defense. The absence of moral choice was recognized on several occasions as one of the essential components for considering duress as a complete defense. A soldier may be considered as being deprived of his moral choice in the face of imminent physical danger. This physical threat, understood in the case law as a danger of death or serious bodily harm, must in some cases also meet the following conditions. It must be clear and present, or else be imminent, real, and inevitable. Mm-hmm. These tribunals also took into account the issue of voluntary participation in an enterprise that leaves no doubt as to its end results, in order to determine the individual responsibility of the accused members of the armed forces or paramilitary groups. The rank held by the soldier giving the order and by the one receiving it has also been taken into account in assessing the duress of a soldier may be subject to when forced to execute a manifestly illegal order. Although the accused did not challenge the manifestly illegal order he was allegedly given, the trial chamber would point out that, according to the case law referred to in such an instance, the duty was to disobey rather than to obey. This duty to disobey could only recede in the face of the most extreme duress. 19. Accordingly, while the complete defense based on moral duress and or a state of necessity stemming from superior orders is not ruled out absolutely, its conditions of application and particularly strict. Its conditions of application are particularly strict. They must be sought not only in the very existence of a superior order, which must first be proven, but also and especially in the circumstances characterizing how the order was given and how it was received. In this case-by-case approach, the one adopted by these post-war tribunals, when it assesses the objective and subjective elements characterizing duress or the state of necessity, it is incumbent on the trial chamber to examine whether the accused in his situation did not have the duty to disobey. Whether he had the moral choice to do so or to try to do so. Using this rigorous and restrictive approach, the trial chamber relies not only on general principles of law as expressed in numerous national laws and case law, but would also like to make clear through its unfettered discretion that the scope of its jurisdiction requires it to judge the most serious violations of international humanitarian law. With regard to a crime against humanity, the trial chamber considers that the life of the accused and that of the victim are not fully equivalent. As opposed to ordinary law, the violation here is no longer directed at the physical welfare of the victim alone, but at humanity as a whole. 20. On the basis of the case-by-case approach and in light of all the elements before it, the trial chamber is of the view that proof of the specific circumstances which would fully exonerate the accused of his responsibility has not been provided. Thus, the defense of duress accompanying the superior order will, as the Secretary General seems to suggest in his report, be taken into account at the same time as other factors in the consideration of mitigating circumstances. In conclusion, the trial chamber, for all the reasons of fact and law surrounding Drazen Erdemovic's guilty plea, considers it valid. 21. In order to arrive at the most appropriate sentence for the case in point, the trial chamber will review the legal context falling within its jurisdiction and will determine the relevant principles applicable to crimes against humanity. In the next video, I continue with 2 applicable law and principles.